Get ready for the dictation. Start. Heard Mr. P.K. Bhalla, learned counsel for the petitioner, and Mr. Deves Pathak, learned additional chief standing counsel, stop para. The petitioner has pleaded that writ petition number 12046 within bracket MB of 2014 was instituted by the petitioner, and in the said writ petition, this court observed that whether provisions of financial assistance for rupees 6 per quintal with the condition to clear entire dues to the farmers for the season 2013-14 by 30/9/2014, which was later extended up to 2011-2014 is arbitrary, unjustified and discriminatory. Stop. In this background, the fact that the petitioner has paid the dues in June 2015 and the petitioner had preferred a representation before the Principal Secretary, Sugar Industries with the request for considering extension of a scheme of financial assistance to facilitate immediate clearance of cane dues to the farmers to that extent, with the assurance that the amount was received under the scheme shall be completely utilized in payment of cane dues. Stop. This court had issued directions to opposite party number 1 to decide the representation of the petitioner strictly in accordance with law, and after taking into consideration the points raised in the representation and pass a reasoned and speaking order. Stop para. It is also pleaded that opposite party number 1, while deciding the representation of the petitioner, paid no heed to the questions raised by the petitioner and observations made by this court in judgment dated 3/2/2017 passed in the above mentioned writ petition. Stop. The impugned order dated 29/5/2017 has been assailed by the petitioner in this petition, by which representation of the petitioner has been rejected by opposite parties without giving opportunity of hearing as claimed by the petitioner, and passed impugned order, which is blatantly arbitrary, illegal, and has been passed in gross violation of principles of natural justice of Audi Ultram Partem. Stop para. It is also mentioned in the grounds of writ petition that this fact was not considered by the opposite parties, that the mill owners, whose financial conditions are sound and have paid dues to the farmers before the prescribed date, were given assistance, and the farmers of those sugar mills have been benefited. Stop. Whereas the farmers of the sugar mill situated in the area of petitioner's sugar mill, whose financial condition was not sound and not able to pay till the prescribed date, have been denied for grant of aid, which is unjustified, discriminatory, illegal, and causes great prejudice and injustice to the farmers and violative of Article 14 of the Constitution of India. Stop. It is also pointed out in the grounds of writ petition that in the year 2014-15, opposite parties granted subsidy / financial assistance of rupees 8 per quintal with the condition to clear entire sugarcane prices towards the farmers for the season 2014-15. Stop. Another writ petition number 7183 within bracket MB of 2015 was instituted by the petitioner, challenging that order. Stop. Later on, opposite parties granted the said benefit of financial assistance / subsidy of rupees 8 per quintal towards sugarcane price to sugar mills, and as such, the petitioner withdrew the said writ petition. Stop para. It is also pleaded that opposite parties in a blatantly arbitrary and illegal manner are depriving of from the said subsidy for crushing season 2013-14 in an illegal manner. Stop. It is mentioned that all sugar mills are in default of section 17 of the UP cane bracket open regulation of supply and purchase bracket close act 1953, depriving certain weak sugar mills from grant of financial assistance of rupees 6 per quintal by way of unreasonable condition imposed, wide order dated 9/9/2014 and press note dated 21/10/2014 is blatantly arbitrary, illegal and hit by Article 14 of the Constitution. Stop. The opposite parties, by imposing condition of clearing complete sugarcane price, dues by a particular date, that is, 30/9/2014, deprived farmers of a financially weak sugar mill from getting due benefit, is unjustified and discriminatory. Stop. There was no valid reason for putting any condition in granting concession when admittedly sugar mills were unable to clear cane dues for reasons known to the government and the subsidy in question has been sanctioned to clear such dues. Stop. On these grounds, following reliefs have been sought in this writ petition. Stop.